expert is necessary for an adequate defense. 9. A picture containing text, newspaper, description automatically generated. 10. Under basic rules of construction, statutory laws enacted by legislative bodies cannot impair rights given under a constitution. 194 BR at 925. Henry Young, 235 BR 666. Banker M.D. Flaw, 1999. The rights of the individuals are restricted only to the extent that they have been voluntarily surrendered by the citizenship to the agencies of government. City of Dallas v. Mitchell, 245 SW 944. Life, faculties, production, in other words, individuality, liberty, property, that is man, and in spite of the cunning of artful political leaders, these three gifts from God precede all human legislation and are superior to it. Frederick Bastiat, born 1801 D. 1850, The Law. http://famguardian.org/publications/the law/the law.htm. For the principal aim of society is to protect individuals in the enjoyment of those absolute rights which were vested in them by the immutable laws of nature, but which could not be preserved in peace without the mutual assistance and intercourse which is gained by the institution of friendly and social communities. Hence it follows that the first and primary end of human laws is to maintain and regulate these absolute rights of individuals. By the absolute rights of individuals we mean those which are so in their primary and strictest sense, such as would belong to their persons merely in a state of nature, and which every man is entitled to enjoy whether out of society or in it. Ibid. William Blackstone, Commentaries, 1765. Source: http://files.libertyfin.org/pl/quotes/215.html. More at Unalienable Rights Course, Form number 12.038, https://sedm.org/libertiu/unalienable-rights.pdf. 11. For the commandments, you shall not commit adultery, you shall not murder, you shall not steal, you shall not bear false witness, you shall not covet, and if there is any other commandment, are all summed up in this saying, namely, you shall love your neighbor as yourself. Love does no harm to a neighbor. Therefore, love is the fulfillment of the law. Romans chapter 13, verse 9-10. Bible, NKJV. Do not strive with, or try to regulate or control or enslave man without cause, if he has done you no harm. Prov. 3:30. Bible, NKJV. 12. A frequent source of anger and frustration is when the government attempts to administratively enforce alleged obligation, most of the time, the government enforcement form, number 05.032, is illegal and even unconstitutional. It is illegal because it disturbs your right to be left alone and therefore represents it. Injustice form number 05.050. It presumes form number 05.017 a civil status, form number 13.008 or obligation you don't in fact have as a justification for the enforcement. This violates due process of law, form number 05.045 if not authenticated by evidence before a neutral third party. Before enforcement commences, it abuses your legal ignorance to victimize you with obligations you don't have, and therefore makes you the target of theft, exploitation, and discrimination by a corrupted de facto government, form number 05.043. It is misrepresented as law rather than merely contract, enforcement or compact enforcement or private law. C. What is law? Form number 05.048. https://sem.org/forms/form-index.htm. 13. The government illegally shifts the burden of proof as the moving party, asserting a civil obligation from themselves to you. They do so with sophistry, equivocation, franchises, and grants loans of civil statuses. Form number 13.008 that you aren't allowed to have. See form number 05.025. It is instituted outside the exclusive geographical territorial jurisdiction of the government doing the enforcing. That location is usually federal territory. See form number 05.018. those wishing to prevent the illegal enforcement must learn how to successfully challenge it administratively and in court, or they can become the target essentially of an organized crime government mafia. Form number 05.043 Trading in stolen private property. Form number 12.025 that technically must be returned to you under asset forfeiture laws. The purpose of this presentation is to show you how to successfully do that. All enforcement actions are predicated on the authority to enforce an alleged obligation. If you can prove that you have not such obligation, the authority of the government to enforce is destroyed. 14. Obligation is defined in the California Civil Code as follows. California Civil Code 104, Division 3. Obligations 1427 3272.9. Heading of Division 3 amended by Stats. 1988, Chapter 160, Sec. 14. Part 1. Obligations in General 1427 to 1543. Part 1 enacted 1872. Title 1. Definition of obligations 1427, 1428. Title 1 enacted 1872. 1427. An obligation is a legal duty by which a person is bound to do or not to do a certain thing. Enacted 1872. The California Civil Code then describe how obligations may lawfully be created. Section 22.2 of the California Civil Code, CCC, shows that the common law shall be the rule of decision in all the courts of the state. CCC Section 1428 establishes that obligations are legal duties arising either from contract of the parties or the operation of law, nothing else. CCC Section 1708 states that the obligations imposed by operation of law are only to abstain from injuring the person or property of another, or infringing upon any of his or her rights. 15. California Civil Code 104, Definitions and Sources of Law. Heading added by Stats. 1951, Chapter 655, in conjunction with Sections 22, 22.1, and 22.2. 22.2. The common law of England, so far as it is not repugnant to or inconsistent with the Constitution of the United States, or the Constitution or laws of this state, is the rule of decision in all the courts of this state. Added by Stats. 1951, Chapter 655, California Civil Code 104, Division 3, Obligations, 1427 3272.9. Heading of Division 3 amended by Stats. 1988, Chapter 160, Sec. 14, Part 1. Obligations in General 1427 to 1543. Part 1 enacted 1872. Title 1. Definition of obligations 1427, 1428. Title 1 enacted 1872. 1428. Section 1428. An obligation arises either from 1. The contract of the parties, or 2. The operation of law. An obligation arising from operation of law may be enforced in the manner provided by law or by civil action or proceeding. Amended by Code Amendments 1873 to 1874, Chapter 612, California Civil Code 104, Division 3, Obligations, 1427 3272.9. Heading of Division 3 amended by Stats. 1988, Chapter 160, Sec. 14, Part 3. Obligations imposed by law 1708 to 1725. Part 3 enacted 1872. 1708. Every person is bound, without contract, to abstain from injuring the person or property of another, or infringing upon any of his or her rights. Amended by Stats. 2002, Chapter 664, Sec. 38.5. Effective January 1, 2003. 16. Therefore, when anyone from the government seeks to enforce a duty or obligation, such as in tax, correspondence, they have the burden of proof. Form number 05.025 to demonstrate one of the following two things. 1. That you expressly consented to a contract with them. This is one of the two mechanisms recognized in Osborne v. Bank of U.S., 22 U.S. 738, 1824, or 2. That operation of law is involved. In other words, that you injured a specific, identified flesh and blood person, and that such a person has standing to sue in a civil or common law action. The main difference between the above two methods of Creating obligations is consent or is absence. Contracts require informed consent while operation of law does not. Comma, for more on consent, see requirement for consent, form number 05.003, forms page, https://sim.org/forms/form-index.htm. Direct link, https://sim.org/forms/05-memlaw/consent PDF. 17. Consent is the foundation of the difference because the Declaration of Independence specifies that all just powers of government derive from the consent of the governed. The only type of law that can operate without informed consent is the criminal law and the common law. Anything done to you civilly without your informed and express consent is therefore inherently unjust. Form number 05.050. Justice form number 05.050 is legally defined as the right to be left alone. Do not strive with, or try to regulate or control or enslave a man without cause, if he has done you no harm. Prov. 330, Bible, NKJV. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred, as against the government, the right to be let alone, the most comprehensive of rights and the right most valued by civilized men. Olmstead v. United States, 277 U.S. 438, 478, 1928. Brandeis, J. Dissenting, C. Also Washington v. Harper, 494 U.S. 210, 1990. If you don't consent to anything the government does civilly, the only choice they have is to leave you alone. It is a maxim of the common law that you should deliver on all your contracts, because when you don't, you take other people's property and impose an injury on their time to regain it, which interferes with their right to be left alone. Contracts create property rights. 18. When anyone from the government asserts that you have an obligation, they as the moving party have the burden of proof. Form number 05.025 to prove it with legally admissible evidence. They may not satisfy that burden with either a belief or a presumption. Form number 05.017. Pursuant to Federal Rule of Evidence 610, neither beliefs or opinions constitute legally admissible evidence. Likewise, a presumption form number 05.017 is not legally admissible evidence for the same reason. We cover why presumptions are not evidence in presumption, chief weapon for unlawfully enlarging federal jurisdiction. Form number 05.017. Forms page, https://sim.org/forms/form-index.htm. Direct link, https://sim.org/forms/05-memlaw/presumption.pdf. That burden of proof begins with speaking truthfully in a verified affidavit signed under penalty of perjury describing the facts which give rise to their cause of action. Such an affidavit is, in fact, what the Declaration of Independence was. 19. In our experience, government has never been able to meet the preceding burden of proof. Form number 05.025 as the moving party asserting an alleged but not actual obligation. They cannot meet the burden of proof because you can't trust anything they say or write or publish, and especially on the phone, in their publications, or on their website. C. Reasonable belief about income tax liability. Form number 05.007. Forms page, https://sim.org/forms/form-index.htm. Direct link, https://sim.org/forms/05-memlaw/reasonable belief.pdf. The only thing the courts say you can rely on is that which is authenticated under penalty of perjury by a fact witness who is legally accountable for telling a falsehood. They never sign anything under penalty of perjury, and therefore can never realistically offer evidence to meet their burden of proof. Government attorneys are not fact witnesses and cannot act in that capacity. They can't in fact be both a government attorney and a fact witness at the same time. Neither can the judge. Even those who can act as fact witnesses must have a delegation order that allows it and cannot have a financial interest in the outcome without committing a crime. 18 U.S.C. Section 208. IRS never satisfies this requirement, therefore, there is no way for the government to satisfy its burden of proof. Form number 05.025 lawfully. It must resort to dishonest and even criminal means to do so. 20, no man can prove they did not do something. No one can prove that he wasn't driving 80 miles per hour down the highway, or that he does not owe a tax. The taxpayer cannot be left in the unpardonable position of having to prove negative. Elkins v. United States, 364 U.S. 206, 218, 80 S.C.T. 1437, 1444, 4L, ed. 2D, 1669, 1960, Flores v. U.S., 551 F, 2D 1169, 1175, 9th Seer, 1977, Portillo v. Comer, 932, F. 2D, 938, affirming, reversing, and remanding 58T, CM 1386, December 46, 373, MTC. Memo 1990 to 196,891 to US TCP 50, 304. Weimerschurch 79 1 US TCP 9359, 596 F 2D at 361. Or that he does not owe a credit card company, instead, he must require those making a claim prove their claim with strict proof of claim. 21. Operation of law involves situations where neither party gave informed consent. Form number 05.003 to the other in any form. Always involves an injury of some kind to the equal rights. Form number 05.033 of one party by the other party, the injury inflicted forms the basis for the following in a civil court: a claim standing to sue in a constitutional court, damages which can be calculated based on the injury, if an injury cannot be proven in court with court admissible evidence, then the case must be dismissed per Federal Rule of Civil Procedure 8b. A mere motion of the court can dismiss the case. Sometimes the judge will dismiss the case without such a motion to reduce his workload, enforcement of the criminal law is another example of operation of law. The victim of the crime received an injury that he or she did not expressly and formally consent to. If, in fact, they either consented to the injury or asked for it, then they have no standing to prosecute the perpetrator. 22. Men are endowed by their Creator with certain unalienable rights, life, liberty, and the pursuit of happiness, and to secure, not grant or create, these rights, governments are instituted. That property or income, which a man has honestly acquired, he retains full control of, subject to these limitations. 1. First, that he shall not use it to his neighbor's injury, and that does not mean that he must use it for his neighbor's benefit, e.g. Social Security, Medicare, and every other public benefit. 2. Second, that if he devotes it to a public use, he gives to the public a right to control that use. And 3. Third, that whenever the public needs require, the public may take it upon payment of due compensation. Budd v. People of State of New York 143 U.S. 517, 1892. 23. Examples of contract obligations include written contracts, verbal, payroll contracts, trusts. The U.S. Constitution is an example of such a trust. Even the Bible is a trust. See Ministry Introduction, Form number 12.014. Delegation of Authority Order from God to Christians, Form number 13.001. Sections 3.8 and 3.9. Civil Franchise Statutes. See Form number 05.030. An example is the Internal Revenue Code, Subtitle A and C, which are public office franchise statutes. See Form number 05.001. Government Employment Agreements. See Title V of the U.S. Code, Informed Consent. Form number 05.003 is the basis of all contracts, Contracts with the government are referred to as privileges, public rights, publici juris, Congressionally created rights. Entitlements. Franchises. Form number 05.030. 24. Comma. If you owe a duty to any government, you are an officer within that government. Comma. Statutory employees under 5 U.S.C. Section 2105 or civil statutory persons form number 05.042 are party to a compact, meaning a contract. Thus, they are government contractors. It is true that the person who accepts an office, a public benefit privilege franchise, may be supposed to enter into a compact to be answerable to the government, which he serves, for any violation of his duty, and having taken the oath of office, he would unquestionably be liable in such case to a prosecution for perjury in the federal courts. The United States v. Worrell, 2 U.S. 384, 1798. Comma, a compact is U.S. Supreme Court shorthand for someone with an implied obligation because they in receipt of government-granted property or benefits and thus subject to direct legislative control by Congress under 5 U.S.C. Section 553. That implied obligation is sometimes also called a quasi-contract. This is also sometimes called a quid pro quo. C. Why statutory civil law is law for government and not private persons. Form number 05.037. Section 2.3. https://sedm.org/05-memlaw/statlaw.gov.t.pdf. Comma, obligations and rights are two sides of the same coin. If you have a right, the government has a corresponding obligation to protect it. If the slave has recognized civil rights, the state protects and is bound to protect those rights, and the obligation is to the slave. Recognized civil rights also imply civil remedies to enforce them, for without these, rights are nothing, and hence the universal maxim of the law, that there is no legal right without a legal remedy. Civil remedies are the legal sanction and 9. Muniment of civil rights, their best criterion and only safeguard. If the slave has civil rights, he must have civil remedies which attach to him as a slave. Bailey v. Poindexter's Exer, 55 va. 132, 1858. Source, https://famguardian.org/tax-freedom/sites/bytopic/civil status. Bailey %20 volt. %20 Poindexter S %20x R %2055 divided by 20 va. %20,132 slave %20 civil %20 status PDF. 25. Comma. Since involuntary servitude is prohibited by the 13th Amendment, then no one can compel you to occupy any government, public office, or civil statutory status. Form number 13.008 to which civil obligations attach, including person or taxpayer or citizen, resident driver, etc. You must volunteer. Comma. Civil obligations owed to governments can include both doing something and not doing something. Comma. In this scenario, a loss of a constitutional right or corresponding remedy owed to you is a civil obligation, such as a loss of the right to appeal to a district court as a taxpayer. Form 05.013 going into tax court. It is an enforceable command essentially to not do something. Comma. Rights are property, as are their corresponding obligations on the part of government. Comma. Loss of constitutional rights or remedies are civil obligations and represent a loss of private property. Form number 12.044. 26. The term office has no legal or technical meaning attached to it, distinct from its ordinary acceptations. An office is a public charge or employment, but, as every employment is not an office, it is sometimes difficult to distinguish between employments which are and those which are not offices. A public officer is one who has some duty to perform concerning the public, and he is not the less a public officer when his duty is confined to narrow limits, because it is the duty and nature of that duty which makes him a public officer, and not the extent of his authority. 7 Bach, ABR 280, Carth 479, where an employment or duty is a continuing 65, 1, which is defined by rules prescribed by law and not by contract. Such a charge or employment is an office, and the person who performs it is an officer. Ricker's Petition 66 NH 207, 1890. Source, https://famguardian.org/tax-freedom/sites-bytopic Public office. Ricker S percent 20 petition percent 2066 divided by 20 NH. Percent 20,207 PDF. 27. The Constitution does not expressly authorize grants of civil, statutory rights, civil statuses, Form number 13.008, or public property to non-residents as a method of creating new extraterritorial public offices within the government. It is unconstitutional. See Article 4, Section 4 of the Constitution. 4 U.S.C. Section 72. Why your government is either a thief or you are a public officer for income tax purposes, Form number 05.007. https://sim.org/forms/form-index.htm. Challenging to Income Tax Enforcement Authority within constitutional states of the Union. Form number 05.052. https://sim.org/forms/form-index.htm. Here is what Thomas Jefferson said about this unconstitutional commercial invasion of the states of the Union in violation of Article 4, Section 4 of the Constitution through illegal tax enforcement. He, the king who we fired, has erected a multitude of new public offices and sent hither swarms of taxpayer public officers to harass our people and eat out their substance. Declaration of Independence 1776. Source https://www.archives.gov/founding. Docs Declaration Transcript. However, there are no constitutional constraints on extraterritorial commerce abroad. Domestic commerce limited to federal territory. We have no territories at this time, by the way. 28. Remember, our real law form number 05.050 is prima facie territorial. Everything extraterritorial must operate through contract, compact, or consent. Form number 05.003 or comity. You cannot lawfully consent to alienate an unalienable right. See Unalienable Rights Course. Form number 12.038. https://sim.org/forms/form-index.htm. Therefore, civil statutory franchise codes can never constitutionally operate extraterritorially within a constitutional state. If it does, it is an unconstitutional invasion and violation of Article 4, Section 4. When civil statutory franchise codes operate extraterritorially entirely by consent, comity, or contract, then it presumes a waiver of official, judicial, and sovereign immunity and operates in equity with the government grantor operating in a private capacity. This is called the Clearfield Doctrine by the U.S. Supreme Court. The administrative state always operates extraterritorially by implementing unconstitutional public offices. Here are its tactics. Administrative State Tactics and Defenses Course. Form number 12.041. https://sim.org/forms/form-index.htm. 29. Anything you expressly provide informed consent to cannot form the basis for an injury.
Volunti non fit injuria.
He who consents cannot receive an injury. To Balve, Inst. N. 2279, 2003-27, 4TR657. Shelf. On Mar. And Div. 449.
Consensus tollici horrei.
Consent removes or obviates a mistake. Company. Lit. 126. Melius estate omnia mala patti quam malo consenter. It is better to suffer every wrong or ill than to consent to it. 3 Company. Inst. 23. Nemo videtur frauder eas qui sent, et consentient. One cannot complain of having been deceived when he knew the fact and gave his consent. Dig. 50. 17. 145. Bouvier's Maxims of Law 1856. Source http://famguardian.org/publications/Bouvier Maxims of Law Bouvier's Maxims htm. Therefore, operation of law can never be used to impose an obligation without a valid contractual relationship that is a product of fully informed consent and demonstrated mutual consideration, unless you violate the contract and therefore injure the other party to the contract, injure a specific flesh and blood human being. 30, consent. Form number 05.003 can be explicit or implicit. Implied consent, that manifested by signs, actions, or facts, or by inaction or silence, which raise a presumption that the consent has been given. For example, when a corporation does business in a state, it impliedly consents to be subject to the jurisdiction of that state's courts in the event of tortious conduct, even though it is not incorporated in that state. Most every state has a statute implying the consent of one who drives upon its highways to submit to some type of scientific test or tests measuring the alcoholic content of the driver's blood. In addition to implying consent, these statutes usually provide that if the result of the test shows that the alcohol content exceeds a specified percentage, then a rebuttable presumption of intoxication arises. Black's Law Dictionary, 5th edition, pages 276-277, if you act like someone who consents, then you are presumed to consent. This is called implicit consent. Procuration, agency, proxy, the act of constituting another one's attorney. In fact, the act by which one person gives power to another to act in his place, as he could do himself. Action under a power of attorney or other constitution of agency. Endorsing a bill or note by procuration is doing it as proxy for another or by his authority. The use of the word procuration, usually per procurationer, or abbreviated to per proc, or PP, on a promissory note by an agent is noticed that the agent has but a limited authority to sign. An express procuration is one made by the express consent of the parties. Implied or tacit procuration takes place when an individual sees another managing his affairs and does not interfere to prevent it. Procurations are also divided into those which contain absolute power, or a general authority, and those which give only a limited power. Also, the act or offense of procuring women for lewd purposes. See also Proctor. Black's Law Dictionary, 5th edition, pages 1086-1087. 31, how the government avoids implied consent on their part by asserting sovereign, official, or judicial immunity, which means that they cannot be sued for injuries, operation of law if they operate within the bounds of their lawful delegated authority, by claiming that you are a party to a contract with them as a citizen, and that by virtue of that contract in you invoking the civil status of a contractor called a statutory citizen or resident, you impliedly consented to their sovereign immunity. Every man is supposed to know the law. A party who makes a contract with an officer of the government without having it reduced to writing is knowingly accessory to a violation of duty on his part. Such a party aids in the violation of the law. Clark v. United States, 95 U.S. 539, 1877, other ways government unlawfully or deceitfully procures your implied rather than informed consent. Requirement for consent, form number 05.003, section 9, government avoidance of legal requirement for consent. https://sem.org/forms/form-index.htm. 32. Consent, an agreement to something proposed, and differs from assent. QV. Wolfens, Nat. Part 1, SS 2730, Part. Dr. Com. Part 2, Tit. 1 and 1, 38-178. Consent supposes 1. A physical power to act, 2. A moral power of acting, 3. A serious, determined, and free use of these powers. Fom. Ec. B. 1. C. 2. S. 1. Prot. Diur belliet passus lib. 2. C. 11. S. 6. 2. Consent is either express or implied. Express, when it is given viva voce, or in writing. Implied, when it is manifested by signs, actions, or facts, or by inaction or silence, which raise a presumption that the consent has been given. 8. 6. Courts of equity have established the rule that when the true owner of property stands by and knowingly suffers a stranger to sell the same as his own without objection, this will be such implied consent as to render the sale valid against the true owner. Story on Ag. Sec. 91. Story on Ec. Jur. Sec. 385-390. And courts of law, unless restrained by technical formalities, act upon the principles of justice, as, for example, when a man permitted, without objection, the sale of his goods under an execution against another person. 6 Adolph, and L. 11. 469, 9 Barn, and Cr. 586, 3 bar, and Adolph, 318, note, Bouvier's Law Dictionary, 4th edition, 1848. 33, comma, notice the language in the definition of procuration. Previously, people doing things for you constitute an offer, and you being silent constitutes an acceptance and consent, comma, in the Uniform Commercial Code UCC, the person performing the services, rendering property, is the merchant. UCC Section 2104(1), sometimes also called a creditor. The person accepting the services, property, is the buyer. UCC Section 2103(1), sometimes also called a debtor. A procuration or purchase of the property or services, which are also property, happens when the buyer does not interfere with the rendering of the services by the merchant. The rendering of the services thereby incurs an implied obligation to render something in return of equal value, unless the property or services have clearly been identified as a gift rather than a loan before they were rendered by merchant to the buyer, comma, this process is abused by the government all the time. It is described in Requirement for Consent, Form number 05.003, Section 10.2. Forms page, https://sim.org/forms/form-index.htm. Direct link, https://sim.org/forms/05-memlaw/consent PDF. 34, comma, important note. Informed consent is necessary for any contract to be valid. Implied consent is not informed consent. Implied consent is also called sub silentio. Implied consent is unethical in the legal field, and you should take extreme measures to ensure that you are never victimized by it. We use the phrase informed consent throughout this presentation to automatically shift the burden of proof back to the government, enforcing a usually alleged but not actual obligation. Informed consent implies true, correct, and complete disclosure of all rights surrendered by accepting an offer by the government. Franchise statutes cannot fulfill the process of informing you if any one of the following applies. You don't consent to participate in them. Government isn't allowed to offer them within a constitutional state. See Form number 05.030. You aren't the party domiciled on federal territory who is even eligible to participate in federal franchises and who is mentioned in the following ruling. Every man is supposed to know the law. A party who makes a contract with an officer without having it reduced to writing is knowingly accessory to a violation of duty on his part. Such a party aids in the violation of the law. Clark v. United States, 95 U.S. 539, 1877. 35. Sub silentio. Under silence, without any notice being taken. Passing. A thing sub silentio may be evidence of consent. Black's Law Dictionary, 4th edition, page 1593.
Qui tacet consentire videtur.
He who is silent appears to consent. Jank. Sent. 32. Bouvier's Maxims of Law, 1856. Source, http://famguardian.org/publications/Bouvier Maxims of Law Bouvier's Max. IMS HTM, California Civil Code. Division 3. Obligations. Part 2. Contracts. Chapter 3. Consent. 1589. A voluntary acceptance of the benefit of a transaction is equivalent to a consent to all the obligations arising from it, so far as the facts are known or are to be known to the person accepting. 36. Comma, you have a right under the common law to not receive a benefit, and therefore property. Benefit and property are synonymous.
Invito beneficium non datur.
No one is obliged to accept a benefit against his consent. Dig. 50, 1769. But if he does not dissent, he will be considered as assenting. Vide assent.
Potest qui renunciar pro se, et sui, jurico pro se introductum est.
A man may relinquish for himself and his heirs a right which was introduced for his own benefit. C1 Balve. Inst. N. 83.
Qui libet potest renunciare juri pro se inducto.
Anyone may renounce a law introduced for his own benefit. To this rule there are some exceptions. C1 Balve. Inst. N. 83. Bouvier's Maxims of Law, 1856. Source, http://famguardian.org/publications/Bouvier Maxims of Law/Bouvier RS Maxims.htm, comma, a failure or refusal to expressly accept or consent to a benefit are the government property it constitutes cannot form the basis for an injury or operation of law. As we pointed out earlier, we cover this further in Government Benefits Scam, form number 05.040, https://sem.org/forms/formindex.htm, if your rights are unalienable as the Declaration of Independent States, then you aren't allowed by law to consent to give them away. Therefore, consent to receive a benefit isn't even rationally possible on land within a state of the Union that is protected by the Constitution and the Declaration of Independence. See Unalienable Rights Course, form number 12.038, https://sem.org/forms/form-index.htm. 37, you can avoid giving consent by identifying you as the only merchant and the government as the only buyer. Identifying anything they give you without you asking for it as a gift, rather than a loan or grant. This is because you aren't allowed to consent to give away an unalienable right. God's delegation of authority in the Bible forbids surrendering rights to any government. https://sem.org/commandments-about-relationship-of-believers-to the world, reserving all your rights on every government form you sign or submit. UCC Section 1308, requiring that all consent must be in writing signed by both parties, prohibiting parole or verbal contracts or implied consent form. Number 05.003, defining all geographical terms that could be subjected to equivocation, and thus bound or renegotiate the terms of the contract. Every form must define all such terms. Under the UCC, the language of the offer and the language of the acceptance must be the same. See Mirror Image Rule, Mark DeAngelis, http://www.youtube embed J8PGBZV757W. 38. Identifying your terms and conditions as the exclusive and sole source to mediate all disputes between the parties. This prevents counteroffers under the UCC. Identifying the government as prohibited from making a business out of offering to alienate rights that are supposed to be unalienable, according to the Declaration of Independence. Therefore, they cannot make a counteroffer. Examples that show how to avoid implied consent. C. Injury Defense Franchise, form number 06.007, https://sem.org/forms/06-avoiding-frank/injury defense franchise PDF. Tax form attachment, form number 04.201, section 7. Constraints on the delegated authority of the submitter in relation to the government. https://sem.org/forms/0-tax/2-withholding/tax-form-at.pdf. Tax form attachment, form number 04.201, section 8. Constraints pertaining to your response to this communication and all communicates with, to, or about the submitter. https://sem.org/forms/0-tax/2-withholding/tax-form-at.pdf. Affidavit of citizenship, domicile, and tax status, form number 02.001, section 5. Mandatory franchise agreement. https://sem.org/0-affidavits/f-sit-dom-tax.pdf. USA Passport Application Attachment, form number 06.007, https://sem.org/forms/form-index.htm. 39. How, then, are purely equitable obligations created? For the most part either by the acts of third persons or by equity alone. But how can one person impose an obligation upon another? By giving property to the latter on the terms of his assuming an obligation in respect to it. At law there are only two means by which the object of the donor could be at all accomplished, consistently with the entire ownership of the property passing to the donee, namely, first, by imposing a real obligation upon the property, secondly, by subjecting the title of the donee to conditions subsequent. The first of these the law does not permit. The second is entirely inadequate. Equity, however, can secure most of the objects of the donor, and yet avoid the mischiefs of real obligations by imposing upon the donee and upon all persons to whom the property shall afterwards come without value or, with notice, a personal obligation with respect to the property, and accordingly, this is what equity does. It is in this way that all trusts are created, and all equitable charges made, i.e., equitable hypothecations or liens created by testators in their wills. In this way, also, most trusts are created by acts inter vivos, except in those cases in which the trustee incurs a legal as well as an equitable obligation. In short, as property is the subject of every equitable obligation, so the owner of property is the only person whose act or acts can be the means of creating an obligation in respect to that property. Moreover, the owner of property can create an obligation in respect to it in only two ways. First, by incurring the obligation himself, in which case he commonly also incurs a legal obligation. Secondly, by imposing the obligation upon some third person, and this he does in the way just explained. Readings on the History and System of the Common Law, 2nd edition. Roscoe Pound, 1925, page 543. 40, rules of property. All rights are property. Anything that conveys rights is property. Contracts convey rights, and therefore are property. All franchises are contracts, and therefore property. Ownership. The essence of owning property is the right to exclude any and all others, including governments, from using or benefiting from the property. If you lose any aspect of control over private property you own, except in the case of injuring others with it, then those asserting such control have stolen your property. That taking of property is a violation of the Fifth Amendment. Takings clause is a trespass under the common law, can be remedied without quoting or using statutory codes. Both the Bill of Rights and the common law are self-executing and don't need any statutes or even the consent of the parties to enforce. Causes an implied waiver of sovereign immunity by the government if they receive or take control of the property. See Armstrong v. United States, 364 U.S. 40, 1960. 41, franchise statutes are the opposite of operation of law, and should never be confused with operation of law, we lump contracts into the bigger category of franchises as a subset of franchises, as contracts, franchises, form number 05.030 only pertain to those consensually, form number 05.003 participating, if you are not a statutory officer or employee of U.S. Incorporated, Federal Corporation, form number 05.024, then the club. Franchise rules don't apply. Those rules are most civil statutes. C. Proof that there is a straw man, form number 05.042. Forms page https://sim.org/forms/form-index.htm. Direct link https://sim.org/05-memlaw/strawman.pdf. Why statutory civil law is law for government and not private persons. Form number 05.037. Forms page https://sim.org/forms/form-index.htm. Direct link https://sim.org/05-memlaw/statlaw.gov.t.pdf, the main source of jurisdiction of any government to regulate anything is franchises. Learn how they work. 42, all civil, other than criminal obligations fit in the contract category and are implemented with civil franchises, form number 05.030. This includes the income tax, all the powers of the government including all of its civil enforcement powers against the public must be carried into operation by individual agency, either through the medium of public officers or contracts made with private individuals. Osborne v. Bank of U.S., 22 U.S. 738, 1824. All franchises are contracts. A contract is not law in a classical sense, but private or special law that only applies to the parties to the contract. Private law, that portion of the law which defines, regulates, enforces, and administers relationships among individuals, associations, and corporations. As used in contradistinction to public law, the term means all that part of the law which is administered between citizen and citizen, or which is concerned with the definition, regulation, and enforcement of rights in cases where both the person in whom the right adheres and the person upon whom the obligation is incident are private individuals. See also private bill, special law. Compare public law. Black's Law Dictionary, 6th edition, page 1196. For court admissible evidence proving that franchises and the contracts they implement are not law. See, what is law? Form number 05.048. https://sim.org/forms/form-index.htm. 43. Special law. 1 relating to particular persons or things. 1. Made for individual cases or for particular places or districts. 1 operating upon a selected class rather than upon the public generally. A private law. A law is special when it is different from others of the same general kind, are designed for a particular purpose, are limited in range or confined to a prescribed field of action or operation. A special law relates to either particular persons, places, or things, or to persons, places, or things which, though not particularized, are separated by any method of selection from the whole class to which the law might, but not such legislation, be applied. Utah Farm Bureau Inc. Company v. Utah Inc. Guarantee as in Utah 564 p. 2d 751 754. A special law applies only to an individual or number of individuals out of a single class similarly situated and affected, or to a special locality. Board of County Commerce of Lemhi County v. Swenson, Idaho 80 Idaho 198 327 p. 2d 361 362. See also private bill, private law. Compare general law, public law. Black's Law Dictionary, 6th edition, pages 1397 to 1398. 44. Tax collectors try to deceive you by making alleged tax obligations look like operation of law, addressing the recipient of tax correspondence as you instead of taxpayers. That means they are practicing law, usually illegally, by making legal determinations about your civil status that they have no delegated authority to make, and which are a tort if they make. C. Your exclusive right to declare or establish your civil status. Form number 13.008. https://sim.org/forms/form-index.htm. Never addressing the following subjects in the correspondence: the existence of those who are not taxpayers. Form number 05.013. C. Your rights as a non-taxpayer. Form number 08.008. https://sedum.org/libertayu/non-taxpayer-bor.pdf. Whether you as the recipient are a franchisee called a taxpayer, the evidence proving that you expressly rather than impliedly consented to the franchise civil status. Form number 13.008 of taxpayer. Whether you are even allowed to consent to become a franchisee called a taxpayer as someone who was never lawfully elected or appointed into public office. You can't, and it's a crime to even pretend that you did. What allows them to even make a conclusive presumption about your status, without even providing the evidence that justifies the unconstitutional conclusive presumption. Presuming, form number 05.017, that you and taxpayers franchisees are synonymous. They almost never are. This represents a violation of due process of law, criminal identity theft, as documented in form number 05.046. 45. On the subject of presumptions. Form number 05.017. A conclusive presumption is one that can become the basis for administrative enforcement without the need to litigate. 4993 conclusive presumptions affecting protected interests. A conclusive presumption may be defeated where its application would impair parties' constitutionally protected liberty or property interests. In such cases, conclusive presumptions have been held to violate a party's due process and equal protection rights. Vlandis v. Klein, 1973, 412 U.S. 441, 449, 93 S. CT, 2230, 2235. Cleveland Bed. of Ed V. LaFleur, 1974, 414, U.S. 632, 639, 640, 94 S. CT, 1208, 1215. Presumption under Illinois law that unmarried fathers are unfit violates process. Federal Civil Trials and Evidence, Rudder Group, Paragraph 8, 4993, page 8K34. It is unconstitutional to make a conclusive presumption about your civil status. Form number 13.008, such as taxpayer form number 05.013 if you are protected by the Constitution as a state national. Form number 05.006. It is apparent this court said in the Bailey case, 219 U.S. 239, 31 S.C.T. 145, 151, that a constitutional prohibition cannot be transgressed indirectly by the creation of a statutory presumption any more than it can be violated by direct enactment. The power to create presumptions is not a means of escape from constitutional restrictions. Heiner v. Donnan, 285 U.S. 312, 1932, Bailey v. Alabama, 219 U.S. 219, 238, ed. The following, 31 S.C.T. 145, Manley v. Georgia, 279 U.S. 1, 56, 49 S.C.T. 215. 46. If you are the victim of illegal enforcement of franchise statutes, then the best approach is to 1. Provide legal evidence in affidavit form that you are not a party to the franchise being enforced. See, for instance, affidavit of citizenship, domicile, and tax status, form number 02.001. 2. File a criminal complaint with the enforcement agent in the Department of Justice identifying yourself as a victim of criminal identity theft. C. Government identity theft, form number 05.046. Forms page, https://sim.org/forms/form-index.htm. Direct link, https://sim.org/forms/05-memlaw/government identity theft.pdf. 3. State that if they do not correct your civil status, form number 13.008 to that of a statutory non-resident non-person, form number 05.020, and discontinue illegal enforcement, form number 05.032, in their actions in contacting you or affecting your property or time they are approaching you as the merchant, UCC Section 2104, 1 of your property and services and time, acting as a buyer, UCC Section 2103, 1 of those services, acting in a private, personal capacity and outside their delegation of authority, order in which they waive official, judicial, and sovereign immunity, agreed to pay you for your services and property as a merchant under the terms and conditions of the following. Injury defense franchise, form number 06.027. Forms page, https://sim.org/forms/form-index.htm. Direct link, https://sim.org/forms/06-avoiding-frank/injury defense franchise PDF. 47. Court remedy for illegal enforcement of non-existent government obligations. A common law action of trespass in state and not federal court against the IRS commissioner and/or the agent bothering you in their personal capacity. Emphasize that the injury defense franchise, form number 06.027, governs choice of law, keeps the case in state court, and prevents it from being removed to federal court. Define the obligations being illegally enforced by the de facto government. Form number 05.043 is neither contractual, a lawful franchise, or a statutory tax. This ensures that the Anti-Injunction Act cannot be invoked. 26 U.S.C. Section 7421. See the following for further details. Flawed tax arguments to avoid. Form number 08.004, Section 8.11. Forms page, https://sim.org/forms/form-index.htm. Direct link, https://sim.org/forms/form-index.htm. forms /08 policy docs /flotargs to void.pdf. The exhaustion of administrative remedies is unnecessary. See Form number 08.004, Section 8.5 above. The full payment rule does not apply. It only applies to statutory taxpayers. Lang v. U.S. 423 U.S. 161, 96 S.C.T. 473, 1976. The court cannot declare you a taxpayer or treat you as one without committing criminal identity theft. See 28 U.S.C. Section 2201. No statutes apply. They only apply to public officer franchisees. See Form number 05.037 and Form number 05.042. Send them a notice of lien for the amount due in Form number 06.027 above. 48, for a practice guide that implements the previous steps in the case of alleged but not actual taxes. See Civil Court Remedies for Sovereigns, Taxation, Litigation Tool, number 10.002. Forms page, https://sim.org/litigation/litindex.htm. Direct link, https://sim.org/iteminfo/ebooks/civcourtrem-tax/civcourtrem tax htm. 49, proof of claim. Your main defense against government greed and corruption form number 09.073. Forms page, http://sim.org/forms/form-index.htm. Direct link, https://sim.org/forms/09-procs/proof of claim.pdf, proof of claim, the key to freedom. https://nickingsites.famgardian.org/forms/topic/IT-all-about-proof-of-claim/ private rights and their protection. Enumeration of inalienable rights. Form number 10.002. http://sim.org/forms/form-index.htm. Legal remedies that protect private rights course. Form number 12.019. http://sim.org/forms/form-index.htm. Unconstitutional Conditions Doctrine, Law Review Articles. See Franchises Unconsconded folder. https://sedm.org/reference/tax-dvd/50, property and separation of private and public. Separation between public and private form number 12.025. http://sim.org/home/government-corruption/private right or public right. Course, form number 12.044. https://sedm.org/libertayu/private right or public right. PDF. Foundations of Freedom. Video 3. Status, Rights, and Privileges. Form number 12.021. Slides. http://sim.org/libertayu/found/freedom-slides.pdf. Video. http YouTube YMC1GPE0GSS. 51, corruption. Government corruption. Form number 11.401. http://sim.org/home/government-corruption/de facto government scam. Form number 05.043. http://sim.org/forms/form-index.htm. Franchises. Government franchises course. Form number 12.012. http://sim.org/forms/form-index.htm. Government benefit scam. Form number 05.040. http://sim.org/forms/form-index.htm. Government instituted slavery using franchises. Form number 05.030. http://sim.org/forms/form-index.htm.